All right, thank you. All right, folks, on behalf of the Graduate School for Education and Human Development, I welcome you to this event. It's called After Affirmative Action, what you need to know about the upcoming affirmative action cases. Here today, we tried to assemble across the spectrum of GW and beyond, admissions professionals, financial aid professionals, to have an in-depth discussion about the two upcoming cases that were just argued this past Halloween and how they may affect your day-to-day operations here at GW. Before we go on, the old adage in education is that people don't care what you know until they know that you care and why you care. So a little bit about my orientation to this subject. My name is Dwayne Kwaysee Wright. Dwayne Kwaysee Wright Barrington III is my full name. I have a bachelor's degree from a historically Black college and university, ethnically from the Caribbean, represent African-American, Black right now as my race. I have a master's degree as well as a PhD in higher education from the Pennsylvania State University and a law degree as well. And in my free time, the little bit of free time I have, I'm an active immigration lawyer in New York, New Jersey, and here in the DC area. I have the privilege of serving as an assistant professor of higher education administration, as well as director of diversity, equity, and inclusion initiatives here at the Graduate School for Education and Human Development at GW, where we call gsehd. All right. A few caveats before we go in. First, as I said, please feel free to use the chat function. We're going to try to reserve as much time as humanly possible. I'm going to go through the presentation very quickly. We're going to try to make the slides available to you. But if you have a question, if there's something that you didn't necessarily recognize, the numbers of the slides are over here on my left-hand screen. It might be your right-hand screen that I'm sharing. So if you need to reference a particular slide with your question, please use the chat function. If you want to ask anonymous questions, we can do that as well. Please send that to me. Or if you don't want me to know who you are, Victoria Mikulowski is here, and just you can DM her as well. So let's get the fine print out of the way. Number one, I am a lawyer. I am licensed, but this is not legal advice. This is not legal advice, and it would not be appropriate for me to give you legal advice. GW hires and pays very well some very good, very experienced lawyers who will come up with the legal advice around these cases. This is for educational purposes only, and this is not legal advice. And number two, this is not a preview of what will be GW University's policy. First and foremost, there won't be a GW response, of course, to the case, I assume, but policy will be developed on a unit-by-unit basis with the guidance of the Office of General Counsel. And I would be shocked if they didn't come out with that close to June when the cases will be decided. So this is not my estimation of what GW policy will be. It's to inform you so you can impact the discussion of what that policy will be. Secondly, this is not based on any insider knowledge or information. Even though I am a lawyer here in the DC area, all predictions are my own. It might not go the way I'm about to describe it. It might go exactly the way I'm describing it. It might go worse, ladies and gentlemen. We really don't know. And anyone that says they know right now has a crystal ball or is just plain lying to you. So I don't want to do that. What this is meant to be is a discussion about the upcoming affirmative action cases and how they may, emphasis on may, impact your day-to-day operations and your policies, all right? So with those caveats, let's begin. And we'll begin at the beginning with the cases, right? So we first have a case, students for fair admissions, and that might be a misnomer or quate, depending on your persuasion in here. And I will try to be as neutral as possible, even though my biases will come out in this presentation, versus the University of North Carolina. And what are the issues presented in this case? Well, whether the Supreme Court, that's the US Supreme Court, should overrule Grutter versus Bollinger and hold that institutions of higher education cannot use race as a factor in admissions, cannot use race as a factor in admission. And also whether a university can reject a so-called race-neutral alternative because it would change the composition of the student body without providing that the alternative would cause a dramatic sacrifice in academic quality or the so-called educational benefits of diversity to the overall student body diversity. If you're wondering why these questions are framed the way they are, North Carolina won on the case below, the lower level of the court. So these are the cases that Students for Fair Admissions, or as we like to call it, SFFA, decided to put towards the court. So this is the framing of the case as presented by the opponents of affirmative action. And we'll discuss why that second question is worked the way it is, hopefully throughout the presentation. But the way, a quick summary, the law is right now is to use race in admissions, you first need to show that race neutral alternatives would not get you the quote unquote same amount of diversity, the critical mass of diversity. So that's why that second question is there as well. Same group has challenged the admissions policies at Harvard College as well. And while the North Carolina case is there, the Harvard case is probably more poignant to the work that's done at GW, and I will explain why. And the issues presented here are whether the Supreme Court should overrule Bollinger and hold that institutions cannot use race as a factor, same as the case above. However, it has this additional question of whether Harvard is violating Title VI of the 1964 Civil Rights Act by penalizing Asian American applicants, engaging in race balancing, emphasizing race, et cetera, et cetera. You can read it there. Again, the framing of this were framed by the opponents of affirmative action. So these are the questions we're here to discuss. They were argued last October, and you can listen to the oral arguments online. oyez.com, OEO has the oral arguments of all Supreme Court cases, as well as C-SPAN. So let's go back to the beginning. Just want to put this up here right now. I really don't like just lecturing into the air, so you can use the chat function. Does anyone recognize what this is? You can peek forward ahead if you want and cheat, but just on a preliminary first look, does anyone in the chat know on slide 7 what you're looking at right now? Anybody?
It looks like the 14th Amendment of the Constitution.
Thank you, Mike, for cheating. I feel like you've seen this. Dean Williams is also a student here at gsehd and is in my legal issues class and is very familiar, but he is right. This is the 14th Amendment of the Constitution. We've had several amendments, the first 10 known as the Bill of Rights. And the 14th Amendment is quite possibly the most important, the most impactful amendment to the Constitution. It has several sections. The first section has to do with so-called birthright citizenship. Anyone born here in the United States, regardless of your parent status, is a citizen of the United States. This is very unique in the context of the law. Then we have the Privileges or Immunities Clause, the Procedural and Substantive Due Process Clause, which has become a little bit of a contention as the qualified right to abortion has been overturned. The focus of this particular presentation will be on the last section, which we call the Equal Protection Clause. And the Equal Protection Clause simply says, and these are the entire words, as you can see from the 14th Amendment, nor shall any state deny to any person within its jurisdiction, and by state we mean the individual states, not necessarily a state like England or France, deny to any person within its jurisdiction the equal protection of the laws, the equal protection of the laws. And this is going to become important as we go through the presentation. The other sort of amendment that we want to talk about was passed in 1964, and it reads, no person in the United States shall, on the ground of race, color, national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program receiving federal financial assistance. And this is Title VI of the Civil Rights Act of 1964. Many of you might be familiar with Title VII, as that governs employment discrimination. And if you ever were in HR training, that's one of the first things they talk about. But the Harvard case, which is the one affecting private schools, will impact Title VI, whereas the North Carolina case, the one impacting public schools, the law that's applicable is the Equal Protection Clause of the 14th Amendment. So remember, folks, if you have any questions, feel free to put them in the chat and we'll get there when we get to the question and answer period. But I do want to breeze through this as much as possible to get there. So with the presentation of the cases and the applicable law, the 14th Amendment and the 1964 Civil Rights Act, emphasizing the receiving of federal funds in the 1964 Civil Rights Act, because this will go beyond admissions, right? So there are many things that receive federal funds, such as research grants, such as endowed scholarships that may be impacted by the Harvard decision, not just the admissions practices of private universities. Okay, with that understood, what is affirmative action? My mentor, friend, Dr. Liliana Garces, and I, many, many years ago, came up with this definition of affirmative action, and I'll explain why we define it this way. The use of any specified identity characteristic as a partially determinative, subjective decisional ground for the assignment of a specified benefit. Now I know what you're thinking, Dwayne, Dr. Wright, whatever you would like to call me, that's probably the most legalese definition I have ever seen in my entire life. Admittedly so, guilty. Here is why we defined it that way. We wanted to make sure that when we talked about the broad category of affirmative action, we weren't just talking about race-conscious affirmative action. So we say the use of any specified characteristic. This definition brings under the large umbrella of affirmative action things like legacy admissions, things like athletic admissions. Again, any specified characteristic that will actually be used as a partially determinative matter in admissions or in deciding a benefit. The benefit for these cases are admissions, but it could be any benefit, recipient of a scholarship, a transfer student that wants to get a scholarship, recipient of book money, or even, if you think about it, the recipient to stay in a specified dorm. If you think about the MOK dorms or the rainbow dorms that we have on college campuses right now, affirmative action would fall under that, even though we tend to focus on race-conscious admissions. This is a timeline of the cases for affirmative action. And what you will notice here is the bulk of the legal discourse on affirmative action has focused not on education, but on employment. From 1979 to 1995, affirmative action was focused almost mostly on employment, particularly after the Bakke case in '78. It was not until the Hopwood case in 1996 and the subsequent Grutter versus Bollinger case in 2003 that affirmative action and the focus of affirmative action, as defined at the last slide, focused back to education. And that's going to become important in a second. But for now, I want to focus on race-conscious admissions, right? Race-conscious admissions. And we start here by presenting these two contrasting statements, and I'll read them to you in full. The first statement, the guarantee of equal protection cannot mean one thing when applied to an individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. And this statement clearly defines equal and equal protection in the Equal Protection Clause of the 14th Amendment as the same. Doesn't matter the context, doesn't matter the history, doesn't matter, it needs to be the same. And this view helpfully articulates what we call the colorblind perspective, And just remember that. And there's a contrasting view that could be summarized within this statement. In order to get beyond racism, we must first take account of race. And in order to treat some persons equally, we must treat them differently. Now, intuitively reading that, you might say, well, Dr. Wright, that doesn't make much sense. But this statement, and I'll try to explain it a little bit in the presentation, articulates a contrasting view to the colorblind perspective, which I and other authors have articulated as the color-conscious perspective. And we're going to try to show through this presentation how these cases and the sort of political, legal, and policy discourse that America is going through right now is a clash between these two perspectives and what should our law embrace, either the colorblind perspective or the color-conscious perspective, I cannot move forward with this without diving into something that I hope you have been exposed to. My colleague, Dr. Jordan West of the Office of Diversity, Equity, and Community Engagement, often in her lectures shows this as well. And I want to show this for two reasons. One, I want to bifurcate equality versus equity, and then come back to those two statements that I just gave you. And you can see, hopefully, here on slide 17, on the picture up top, the difference between equality and equity, right? Equality is just giving everyone the same, milk carton to try to see this baseball game right here. Whereas equity takes in the context that one person doesn't need a milk carton. Another person only needs one. And even if we only have three, there's a person that needs to see the ball game needs two, right? So if I just said to you, hey, I've got three things to give out equally, and I have three people to give it, equality would mean giving them exactly the same. Whereas equity takes into consideration who needs what in order to get what. Oftentimes we hear equity forecast described as a radical tradition. And I want to sort of dissuade you of that. And I want to use the picture below to do that as well. The same picture below has two pictures, one describing equality, one describing equity, but one that removes the fence at all. We often talk now in America, post George Floyd, post Breonna Taylor, and the many, many Black people that died unarmed, of what would be systemic change. And if we're talking about equality and equity, neither of those are really systemic change. Systemic change is removing the fence altogether, right? Rather than talking about free college, can we have open access colleges? Today, we'll be focusing on the contrast between equality and equity, but I did not want to lose the fact that many people have the goal of removing the fence altogether. All right, moving on very quickly. The two statements that I came below weren't just brought out of the sky. They came from the defining case for affirmative action so far, Regents of California versus Bakke, and they were stated by, at the time, two Supreme Court justices, both appointed by Republicans, Justice Lewis Powell, appointed by Ronald Reagan, Justice Harry Blackmun, appointed by Richard Nixon. And Justice Powell's view, the colorblind view, clearly focuses on equality. Whereas Justice Harry Blackmun's view clearly focuses on equity. So I want to focus, this sort of contrast between the colorblind perspective and the color conscious perspective on this sort of bifurcation, this sort of clash, if you would, of where should policy and law go? Should it focus on equity or should it focus on equality? So I want to focus now on Regents of California versus Bakke. On my left is Alan Bakke, who was applied twice to the UC Davis Medical School. And on my right is Justice Lewis Powell, whose lone decision, not 5 justices, not 6 justices, it was only him, became the way that we decided affirmative action. And then that decision was then codified in the Grutter case, which the opponents of affirmative action are asking us to overrule today. Now, before we go on, I want to emphasize the elephant in the room. We haven't talked about it yet, and that would be race, right? Cannot talk about any of these without talking about race, the impact that anti-Black racism has on us, the impact that white supremacy has on all people, including white people, and the impact that race and racism has on our students, our faculty, and our staff here at GW. So just a few unifying concepts that I want to just run by you. I'm not asking you to necessarily agree with these, but I just want you to know where I'm coming from in this presentation. What is race? Race is a method of classifying people, not controversial. Race, we say, is a political and social construction. Race is, whether we want it to be or not, an important part of American culture and history, and race is defined by the majority. To be Black is to be not white, right? A lot of Black culture has developed independently of whiteness and the concept of whiteness, but as constructed, to be Black is to be not white, or as Ta-Nehisi Coates put it in Between the World and Me, race is the mother, race is rather the daughter of racism, not the mother, right? Racism came first, and then came the concept of race. More importantly, race is not ethnicity or nationality, right? And you'll see why this is important. Many of you might be thinking, well, Dr. Wright, suppose the affirmative action cases go the way you think it is, and we can't do affirmative action based on race. Why can't we just do it by ethnicity or nationality? Well, there are laws sort of constricting that as well, but I do want to acknowledge that ethnicity has to do with ancestry, culture, and language. I am by race Black, by ethnicity, I am Caribbean. I was born in Trinidad and Tobago. Nationality has to do with the laws of the land. We know that there are many, many Americans, some that have been here longer than I, that will never be American. Some of our undocumented Americans, some of our DACA students. Race, ethnicity, nationality, 3 different constructs. And then I want to come back to this sort of what is racism? And your answer to this may contrast with the colorblind perspective, the race neutral perspective, and a color conscious perspective. The colorblind perspective is that race should never matter to a decision maker, and it's never necessary to use it to increase racial equality. The race neutral perspective is the consideration of race is not necessary if other characteristics can and produce as much racial diversity. So use race as a last resort. The color conscious perspective, in contrast, and I want to be upfront in my views, this is probably the view that I am most associated with, is the use of race is necessary if we are to address racial inequality. Each, I think, has the goal of making race not matter in the future. The difference is how we get there. I think the colorblind perspective is, let's just stop using race right now. The color neutral perspective is, let's limit the use of race to only when necessary. And the color conscious perspective is, you cannot cure the racial problem without dealing with race. All right, a quick time check. Let's skip forward to the current law. So you might say, okay, Dr. Wright, I get you on race. I get you on the current cases. What is the current law right now? And how would the affirmative action cases modify the current law? So to understand the current law right now, you need to understand what we call levels of scrutiny, And several of my students are here today. If I had more time, I would, show off the great work we do at gshed by letting them explain this as they're getting ready for their final on Thursday. Don't be nervous, students. I'm not going to do that. I said, if I had more time. Here's how this works. If you wanted to challenge any government decision, so whether that be a law of the state of Maryland or the Commonwealth of Virginia, or whether that be a decision by a government actor, who is doing something, let's say the president of a public school, we have those that are called the levels of scrutiny. And the way levels of scrutiny work is, first we classify the group that's being so-called discriminated against. We say, what classification does that group fall into? And then we decide what test needs to apply. So for certain classifications, wealth, alumni status, geography, everything that isn't a suspect or quasi-suspect class, we call that a rational basis review. The government only needs a legitimate interest, very, very low. Doesn't even have to be the government's real interest. If the government can invent an interest, that's good enough for the court. And the way the government implements that interest needs to be rationally related. For other concepts, for other classifications, gender identity, and sexual orientation, we say that the classification needs to meet intermediate scrutiny. Rather than just a legitimate governmental interest, you need another level, an important governmental interest, and how you implement that interest needs to be substantially related. Finally, for certain so-called suspect classifications, race, national origin, in some instances, citizenship status, it's the highest test. We call this test strict scrutiny. For strict scrutiny, not a legitimate interest, not an important interest, you need something that's called a compelling governmental interest. And how you implement that interest needs to be narrowly tailored to that compelling governmental interest. If you're going to, focus on any slide, when we send out the slides, I would say this is the slide to focus on, slide 30, and I'll try to explain why. So for our instances, we're going to focus on strict scrutiny because we're talking about race-conscious admissions. For the purposes of either Title IX, Title VI rather, or the purposes of equal protection, it does not matter if the racial benefit helps or hurts minorities. Just the classification of itself puts us in strict scrutiny land. And the first thing you need for strict scrutiny is you need a so-called compelling governmental interest. And here are a summary of a few of our compelling governmental interests. National security, preserving the lives of a large amount of individuals. Why were we able to curtail certain student protests during COVID? Because that has been decided by the court to be a compelling governmental interest. Avoiding violating another constitutional provision, remediation of prior proven de jure race-based discrimination. If a court said in 1965, GW discriminated against, and therefore GW has to do X, Y, Z, that's a compelling governmental interest. And the one we're going to focus on for the rest of the presentation is diversity in higher education. I say almost nothing else counts, and that is sort of true. Legally, that's not 100% accurate. The court determines what its compelling governmental interest is, but for your purposes, almost nothing else counts. And we get this sort of system, the level of scrutiny system, in combination with diversity in higher education from this Regents of California versus Bakke case. Now, you might say, well, Dr. Wright, why are we only using diversity in higher education? There are many other compelling interests or interests that I would think would be compelling to justify the use of race in college admissions. Well, in that Bakke case, Justice Powell examined some other reasons, and he determined, and the court then codified his determination, that they were not compelling enough. What would be some examples of those things that aren't compelling enough? Racial balancing, right? 40% of Georgia is Black. I don't know that to be true. I'm just saying. So therefore, we'll have 40% of people in the University of Georgia to be Black. Not a compelling governmental interest, cannot justify the use of race. Countering the effects of so-called societal discrimination. Today, we would call that maybe systemic discrimination. Not a compelling interest, not enough. Increasing the number of physicians. The University of California at Davis said, look, the reason we have this set aside, this quota, 16 seats out of 100 only for minorities, is because we need to increase the number of minorities serving people, let's say in Compton, serving people, let's say in Southeast here in DC. Why can't we do that? The court said that so-called role model theory was not a compelling governmental interest. The only compelling governmental interest we have is the so-called diversity rationale in higher education. And once again, folks, this is the way the law is right now. Right now, we're going to get into how this would be modified if an adverse ruling to affirmative action happened in the two cases. The diversity rationale is the defense of affirmative action policies, not based on remediation. So not based on the 300 years of discrimination and, slavery that African Americans and other people of color had to do in America, but the compelling interest in diversity. What does that mean? It means the interest in having a critical mass of minoritized students so that all students can get the benefit of diversity. In other words, it's been defined as having the goal of obtaining enough students that underrepresented minorities, so that the school environment would enable all students at the school to obtain the educational benefits of diversity. Now, you might say, well, Dr. Wright, what's enough students? I don't know. I did a dissertation on critical mass. I've been studying this now for the last 15 years, and I still don't know. I hope the court, in whatever decision it turns out in June, gives us a little bit more guidance. But what does this mean in layman's terms? It means that quotas, those 16 seats that we set aside for minoritized students in Bakke, that is bad. It's not narrowly tailored. There's no defense for that. You can't do that. Goals are good. Having the goal, which is not a number, so it doesn't change into a quota, of obtaining enough students, whatever enough means, to get the educational benefits of diversity, that's okay. And if you can get those same benefits, and this is key here, if you could get those same educational benefits without using race, the court says, matter of fact, that would be even better. And that is our current stance of the law. And you probably can see amongst the different perspectives on how to solve America's race problem, some would say America's racism problem, that the current law sort of embraces the race neutral perspective. The current law embraces the race neutral perspective. Unlike the colorblind perspective, the color law will allow you to use race as a goal, as using the critical mass, if you can prove that it's necessary because you've used everything else and you can't get diversity, right? Unlike the color conscious perspective, which wouldn't even put you through that, you understand, you do need to exhaust all your race neutral options to use race under the current law. This is the race neutral perspective. This is the diversity rationale, and this is how the law is right now. So I just want to pause there and say, remember, we will take questions at the end. If you have questions on any of this, feel free to write down the number on the slide. You understand, we'll come back to it, and we'll use questions at the end if you wish, and you can put them in the chat right now. So the diversity rationale is the so-called narrow tailored use of race in admissions. to further the school's compelling interest as it exists right now of obtaining the educational benefits that flow from diversity. Under this sort of synopsis, race is just the key to get into the door, right? What you really want to get to when you get into the apartment is the educational benefits of diversity. And therefore, if you could use something else other than race to get to those educational benefits, the court would like you to use that under the current law, What does narrow tailoring mean? Narrow tailoring is an analysis of whether any race-neutral alternatives could produce the educational benefits of diversity. It's an analysis of whether you can use economics rather than race to produce the educational benefits of diversity, whether you can use geography, top 10% plans, right? So, coming this June, court says I can't use affirmative action. I'm going to, can't reserve, quotas are never good. I'm going to give a benefit to students that come from, let's say, the Southeast section of DC. Non-suspect classifications, legacy admissions, athletic admissions, plus to students that can show that they can shoot a 3, very good, athletic admissions. All of those are race neutral admissions. And what we mean by narrow tailoring is you have to use and show that any non-racial means you have been exhausted before you can use race. And that is the current system. Race classification means strict scrutiny. Strict scrutiny means you needed a compelling governmental interest. Your compelling interest is diversity. Narrow tailoring means I've at least had an analysis. You don't have to execute the plan, but I've run a few scenarios to show that unless I use race, I could not get the same educational benefits of diversity. So moving right along, because I do want to get to questions rather quickly. I want to focus on equal protection. So we bifurcated the levels of law. We said the equal protection clause will apply to the North Carolina case because that is a public school. The North Carolina case, because that is a public school. And I want to emphasize the importance of intent in equal protection. Equal protection only applies to state action, which can be proven the government intentionally assigned someone to a burden or a benefit. If you had a race-neutral alternative, such as economics, that resulted in race disproportionate applications, that's not what equal protection attaches. So we're talking about equal protection, the equal protection clause in the North Carolina case, and to emphasize, we're talking about the intentional discrimination. Affirmative action, a plus for any characteristic, if it's a racial characteristic, it's strict scrutiny, is intentional. It's intentional. I want to clarify that. All right. So if we're talking about race-conscious employment, let's say, quotas for women engineers in the Army Corps of Engineers, what we would ask for is an important governmental reason, and we would test if the way you're trying to get to that reason is substantially related to the means you actually want to use. Let's say we wanted to do something else, sexual orientations conscious admissions at the University of the District of Columbia, which, yes, I know DC is not a state, but that's still a state actor, right? Well, it would depend. I think the court would view that under intermediate scrutiny. Some other people still argue from the past that that would be rational basis. Let's say if it's intermediate scrutiny, much like the gender conscious employment, what we would ask if the University of the District of Columbia wanted to have a plus factor, let's say for members of the LGBT community, right? They would have to show an important governmental reason for that plus factor, for that discrimination against non-LGBT members, and the means in which they try to get to that important reason must be substantially related. It cannot be too broad or too narrow. Now, you might notice in here, before we try to get through this to get to questions, that a gaping lack of a concept that we have become rather familiar with in academia, at least the academic side of it, called intersectionality. And if you want to say, well, Dr. Wright, my problem in my unit is that we don't have Black women. I have plenty of women, they just don't happen to be Black. I have a fair amount, can't say plenty at GW, but a fair amount of Black students, they just happen to be all male. What if I wanted an affirmative action policy specifically for Black women? And for whatever reason, we haven't advanced the law to that point. Our levels of scrutiny right now do not have any type of intersectional sort of analysis, all right? So just remember, if you're doing that, you need a compelling governmental interest. Anything else besides suspect and quasi-suspect or rational basis, you should be good. So let's talk about this Title VI case because it's rather interesting. First and foremost, what I need to say here is the Supreme Court has never really said that Title VI runs the same as equal protection. When I just explained to you the current law is equal protection. What we're assuming as lawyers, because there is one throwaway line in a case called Alexander versus Sandoval, which the court sort of implied that Title VI and equal protection, 14th Amendment are coexistent, okay? So we're assuming, you know what happens when we assume, but we're assuming that the court's assuming that Title VI and equal protection run the same, but they don't cover the same. They don't cover the same. I want you to think of Title VI of the 1964 Civil Rights Act as the Title IX for race. Title IX for race. We know we have a Title IX office here. We had extensive discussion at the last faculty senate meeting about Title IX training. You know, the Title IX applies because an organization takes federal funds. Title VI of the 1964 Civil Rights Act also applies because an organization takes federal funds. Just like Title IX, it applies to K through 12 organizations, just like it applies to other organizations. Sorry about that, folks. Alexa wanted to help along with the lecture. She is as excited about affirmative action as I am. Title VI, right? The Title IX equivalent. As Title IX applies to K through 12, so does Title VI apply to K through 12. And it applies to any organization, not because they're universities, because they take recipients of federal funds. What is the recipient of federal funds? Well, the most basic recipient of federal funds, how someone becomes a recipient of federal funds is by participation in the student loan program. Now you may say, Dr. Wright, that's not, we don't get that money. Well, you do, right? You get the money from the federal government and the student pays the federal government back. That qualifies any university that takes the participation in that. Title IX, Title VI applies. Because this applies to organizations that are recipient of federal funds, it will not be limited to just university admissions policy. It would also extend to financial aid policy, research policy, medical schools use because they're taking in Medicaid, which is also a federal fund. We don't really talk about Title VI a lot, but this Harvard case is going to bring it back into conjunction, all right? So equal protection for the North Carolina case, Title VI for the Harvard case, and this is why we're talking about this at GW. If this was just the University of North Carolina case, we might say, hey, really interesting, but it's not going to apply to us. But the ruling in the Harvard case will directly apply to the admissions, financial aid, and other policies here at GW, including, like I said, residential policies as well. What is this case trying to do? Well, both the North Carolina case and the Harvard case are trying to shift the balance of the law as the balance of our court has shifted. As now we are in the race neutral perspective. What an adverse ruling against affirmative action would do in these two cases is impose legally the colorblind perspective on our policy. It would impose legally the colorblind perspective on our policy. As of right now, the race neutral policy is the current law of the land. You can use race as long as you can prove you can't get the educational benefits of diversity through any other race neutral means. A shift to the colorblind perspective and an extension by the court of equal protection to Title VI jurisprudence would place the colorblind perspective, no race at all for any reason, into the law of the land. What would that mean? That would mean that even if you can prove that, Dr. Wright, there's just no way I can get qualified chemistry students without considering race. My class would be all white, or at least non-Black for the next 5 years. An adverse ruling against affirmative action, against race-conscious submissions in this context would say that doesn't matter. And once again, I want to show that this view, in my opinion, might be problematic, but there are many Americans, many of your colleagues, many people that hold this view, right? So I'm not saying that, you know, if the court were to embrace this view, the sky necessarily would fall, but we should talk about some of the negative ramifications that would come from such a ruling. So if you're asking, you just went through all those slides, Dr. Wright, what is the core issue? It's that shift. The shift from the current law's embrace of race-neutral perspective to the embrace of the colorblind perspective. And because we're talking about both equal protection and Title VI, the imposition of the colorblind perspective on the policies of both private and public schools. All right. With that said, I want to turn within the next 5 minutes or so to questions. I do see a few in the chat. What should you be prepping for, right? What should you be prepping for? So the opinion will be handed down in June, usually right around my birthday, June 26th, is when the end of the term is. That's when all the major opinions come. Hopefully, we won't have a leak this time. For the Dobbs decision, we had a leak. I don't think that will happen this time. So you're waiting until June. The problem there is many of you would be ending admission cycle or financial aid cycle and getting ready to start a new one based on the current law, I've got questions before, well, will there be a sort of phase-in period? Dr. Wright, I'm familiar with Title IX policy. They gave us 6 months to accommodate. This is a ruling on an interpretation of the Constitution and the law. There is no phase-in period. You might wake up on June 29th, and you might wake up on July 1st, and what was legal on June, or constitutional is a better word, on June 29th might not be constitutional on July 1st. So what should you be preparing for right now? So this is a prediction, if SCOTUS decides that private universities, because we're talking about GW now, cannot, based on Title VI, use race as a consideration in admissions, here's a few things I think you need to think about. How, if at all, are you using race as a factor right now? And if you're sure you're not using race as a factor right now, then you might be good. Doesn't mean you're not going to be challenged, right? But you might be good. So you might want to start surveying your policies and procedures to see how race is being used right now. Number two, are there ways you could produce the same amount of racial or ethnic diversity? Now, it's not diversity for diversity's sake. It's diversity because we know diversity produces the educational benefits of diversity without using race-conscious admissions. Have you considered race-neutral alternatives? Have you considered socioeconomic status? Have you considered, could it be ethnicity? Have you considered other non-racial alternatives to get the same type of class that you want? If, and here's more of a policy question, and I'm a legal analyst, but I do delve in policy as well. If your diversity numbers are going to go down in any significant way, what is the plan to communicate this to your unit? Particularly your students of color, your staff and faculty of color as well. As a predominantly white institution, we know that we already have certain challenges and struggles with admission right now here at GW. If that is going to change within the next 8 to 9 months, we need to prepare our community for that. So we're not caught, empty-handed, with our pants down, use whatever crude analogy you wish. You understand? I don't know if many of you knew, but right now there's an ongoing protest right now at Georgetown University about racial incidents. Our students joined that protest, and last Friday at Colgan Plaza had a protest. And if you think that, the aftershocks of George Floyd are over, they're not. They might be over for some people, but for our faculty, students, and staff of color, they're not. What is your plan if you're not going to be able to maintain the levels of diversity that you have to, announce this to the community, have a plan, and, even if that plan is not sufficient, explain that plan to your unit and the unit you're responsible for. Next one. What if the plan, and you make this plan, and the court upholds race-conscious admissions? Why is this in bold? I want to emphasize this because I have discussions with members of general counsel around the country, not our general counsel, and they say, Dr. Wright, I'm pretty nervous that you're even doing this. Well, I said, why? Because I'm afraid that if people start to do this preparation and they come up with race-neutral alternatives and the court doesn't strike down affirmative action, they will be mandated to use those race-neutral alternatives. Because remember how strict scrutiny works. For it to be narrow tailored, you have to show that race-neutral alternatives cannot get the same amount of diversity. So as you're creating these plans, you need to be in lockstep with university administration and lockstep with general counsel, because everything you create could be subpoenaed. And if, my prediction is 80-20 affirmative action is dead. If that 20%, right, the 2016 election was probably 80-20, right? If that 20% actually comes up, you don't want to put yourself in a position where you've could cut your nose off to spite your face, as we say in the Caribbean. And finally, what are other areas of operations that will be impacted by the Title VI ruling? Do you have certain scholarships by donors that are race restricted that might have flown under race neutral perspective, but will not fly under a colorblind perspective? Are there dorms here where we assign people based on race? Do we give racial preferences to students to assign them to dorms? Other areas that might be race neutral that go beyond admissions that might be impacted. So in summary, we're talking mostly about Title VI of the 1964 Civil Rights Act. We're talking about the impact that the Harvard case might have. It's going to move us from the race neutral perspective to the codification of the colorblind perspective. And now we're going to go to questions. I'm going to go to the chat first, and then we're going to sort of hold a sort of forum, just sort of questions, open discussion in here.